And let me thank you for inviting me to this symposium this afternoon. May I thank the Dean, Dr. Mohan, Honorable Attorney General, the Dean of the former Dean of the Open University, and of course my learned friend and perhaps one of the most senior and dynamic lawyers we've had in Sri Lanka, at least Mr. Kumin Dayasiri, and of course the Vice Chancellor and the faculty of the KDU. I'm happy that your Dean actually complied with my direction lest I actually hold him up for contempt of court. I did direct him to tell you that I was once upon a damn good lawyer, then the Attorney General, and then now here I am as Chief Justice. So good afternoon to all of you. I'm not too sure as to whether to talk of the rule of law in this in the given setting is just the kind of thing for an after lunch kind of presentation. But let me try and make it as interesting as possible as it can be. And let me use the simplest of language as I can. Unfortunately, law is so enmeshed in language that we are enjoined actually or compelled sometimes to use language whether we like it or not. Don't worry too much about the language because I'm sure at the end of the session you will be free to ask me any question that I can answer. That's what the mandate is. So let me just get on quickly with what I'm tasked to do this afternoon. Now, I'm particularly happy, Dean, that today's occasion, namely the KDU International Research Symposium for 2013, focuses on a very timely and a very timely topic of theme, Sri Lanka as a hub in Asia. ආසියාවේ ආශ්චර්ය කරන්නේ කොහොමද කියන අපේ රට. That's the long and the short of this whole story. As far as the sessions on law are concerned, I'm told that the emphasis is on good governance and the rule of law. Now, these are very nice words to use, good governance and the rule of law. I'm not too sure whether you find it any part of the world. So don't worry too much about what we are doing, because I can tell you, I'm sure Gomil will agree with me and Reggie, that we are doing everything in the book to ensure good governance and the rule of law in this country. Except that no amount of governance and no amount of compliance appears to satisfy the so-called international community. So don't worry about it. We are doing our best. You are doing your best. And I'm fairly sure sooner than later we will become the Ascharya of Asia. That is what we will be. Now, given the priceless opportunity that each one of us has today at a very, as I said, a very crucial, an important moment of our country's history, to participate in a process that will take this country to a significantly unique position in Asia. I have that confidence. Now, this conference is therefore, in my view, indeed essential, important to a common understanding of the role of each one of us in a democracy, the role of each one of us in the development of common values. අපේ රටේ තියෙන ගුණාත්මක අපේ ශිෂ්ටාචාරයේ සංස්කෘතියේ තියෙන ගුණාත්මක භාවය, right? To strengthen solidarity and of course to learn from each other in every possible way. Now that's the task that is before us. Now at first blush, Balu Belmata, I entertain the view that your sessions on law invites me to the view on the role of the judiciary. Now, you didn't invite me perhaps to tell you all about what I'm doing in Hulstorf. No. But you probably want to know from me, well, you people are sitting there in those lofty places. What are you going to do for the benefit of this country towards contributing to making Asia, Sri Lanka, the miracle of Asia? So I'm sure you would want me to tell you something about it briefly, right? And if one was to find a link between good governance and the rule of law and the final goal, Sri Lanka as a hub of Asia, I would say that the final accomplishment, like the final accomplishment in any kind of operation, of having Sri Lanka a hub in Asia would have to be brought by employing these devices of good governance and the rule of law. In other words, we have ආසියාවේ ආශ්චර්ය කිරීමට පුළුවන් අපිට තියෙන සෑම යාන්ත්‍රණයක්ම අපි උපයෝගී කරගත යුතුයි කියන එකයි මම මේ කියන්නේ. Now, if you perceive good governance, if you understand the concept of good governance and the rule of law as the path or the roads that lead to Sri Lanka becoming a hub in Asia, now your invitation, I say, boils down to posing me one question. There is one question, Pratibha, I would like to pose. And that is, how does the judiciary help in this process? අධිකරණමය ක්‍රියාවලිය කොහොමද මේකට අනුග්‍රහය දක්වන්නේ කියන එකයි මේ ප්‍රශ්නේ. Now, in addition to good governance, permit me, may I have your permission, to add two other desirable paradigms, namely, තව තියෙන පරාසයන් දෙකක් තියෙනවා, namely, peace and sustainable economic development. Peace, good governance alone, you can frame good governance on the wall. If there is no peace and sustainable development that we can අපිට දැරිය හැකි සංවර්ධනය කියන එකයි. Otherwise, good governance, these are nice words to use, lovely things to talk about. Good governance, there must be peace and there must be sustainable development. Now, in my view, it is not only good governance and the rule of law, but also peace and sustainable development, I have said this in Geneva a million times, that are indispensable adjunct. In fact, when I was drafting this, I remembered the words I used in Geneva 3 years ago. I told the Council that you can talk of human rights to a group of people who are full on their stomachs. You can talk of human rights to a group of people who have homes to live in. You can talk to people who of human rights to a lovely economy, a sustainable economy. But can you talk human rights to a people on empty stomachs, who are sleeping under trees, who do not have money, who cannot go to a school, who can't send their children to a university? Now we are asking them to, to live up to all those lovely human rights. So I use this expression that it is an indispensable adjunct to the sustaining of human rights, to achieving that final objective. And I say, I link it here, and I say that is the same thing I say, good governance, peace, and sustainable development, all these are indispensable adjuncts to achieving the final objective of making our country a hub of Asia. That we have to remember. No, so therefore, I would say that as a way forward, what is the forward direction? As a way forward, let me rephrase the question. Dean, let me rephrase that question and put the question this way. How does the judiciary help in promoting peace, in promoting good governance and sustainable development? Now, we judges sometimes think that sustainable development and peace and governance is something for the government. We tell ourselves that we are some God-given gift to mankind who are in kind of ivory towers, who detach ourselves so badly that we actually lose sometimes the connection, the engagement. We don't have a feel for what is actually going on. Now, that was an old style of doing things. Only, in other words, next to, of course, we judges tell ourselves that we judges are of a monastic order. Api pujaka varunhata asamanai kiyala. ඒ නිසා අපි කොයිලා එක කාලයක් තිබුණා. අපි අහසේ පාවෙමින් සිටින කාණ්ඩයක්. That was the kind. But that has changed. All that today has changed. We are no longer that breed of person who actually, So we are no longer the breed of people who are, floating in cloud nine, but we today, the judiciaries of the world, today are engaging closely, rapidly with economic development, rapidly with the affairs of the country, and rapidly with peace, good governance, and sustainable economic development. Let me just usher SL in, and then we can take it from there. Hello, sir. Hi, good to see you. Please. Now, can I just get back to what I was saying? Now, so how does the judiciary help in promoting peace, good governance, and sustainable development? Now, not that I have made an omission of the rule of law. That doesn't mean that I've completely forgotten the rule of law. I find the rule of law as the overarching, it has a kind of overall impact, an overarching device that will catalyze the promotion of peace, that will catalyze good governance and sustainable development. Now, therefore, ladies and gentlemen, at the heart of the judicial role is the observance of the rule of law. At the heart, at the very core, nyashtya, is the rule of law, which I had occasion to refer to in my ceremonial address when I assumed office as Chief Justice. I said that at the very first day, and I continue to say that. I will incessantly say that in the future. Now, therefore, let me come to the rule of law shortly, but now permit me to turn the debate on the role of the judiciary, in this process of making Sri Lanka a hub of excellence. Now, there exists, or there used to exist, or perhaps there still exists, a school of thought that advocates the thinking that the judiciary has no rule of this kind in governance. There is a very traditional approach, and to say that the courts must do what the courts traditionally are known to do, and it should not mingle or perhaps meddle with government. Now, as you are well aware, it is based on the well-known theory, you will have been taught this, of the separation of powers. Now, separation of powers was used to kind of drive it into your head that there are three compartments, and they will be compartmentalized. Now, the thesis is often advanced, the thesis that was often advanced, was that judges should have no role to play in governance at all. That was the very old traditional way of thinking. Now, judges should determine the cases. The thinking was that the judges should look at the cases before them in a judicial way. The executive and the legislature must govern. Indeed, the judiciary had no power to influence the conduct of government directly until more than 200 years ago, when things began to change. That was the turning point. Now, the courts then, before that, essentially performed the function of interpreting and giving meaning to the rules agreed to in contracts and in determining disputes of fact in civil and criminal matters in the process of enforcing what I would call societal norms, standards. Today, you will see around, you will probably agree with me if I was to say that things are different. Things are clearly different. It is now, therefore, ladies and gentlemen, almost universally agreed that the doctrine of the separation of powers implies no absolute distinction. There is little disagreement with regard to the fact that there is no bright line, no clear line that demarcates the separation of powers between the legislature and the executive on the one hand and the judiciary on the other. So there is a huge shift from what it was then to what it is now. But the exercise, I say, of the checks and balances that the judiciary performs must be within permissible boundaries permitted by the Constitution and any other law. In other words, the departure, of course, is confined to the permissible departures as prescribed in the Constitution. That is the position. Now, in many constitutional democracies, if you read a little, you will see that in many constitutional democracies, like South Africa, the United States of America, India, and Germany, courts play some role in ensuring that government complies with the Constitution and the relevant statutes. We see that even in our own country. Now, and I would therefore suggest that the primary requirement of good governance is that the legislature and the executive must ensure that they comply with the Constitution in every respect. Now, that is a fundamental rule. Now, don't misunderstand me. This does not mean, and I say it for emphasis, this does not mean compliance with the letter of the Constitution literally interpreted. Not literally interpreted. This does not mean that the courts play an interventionist role in the guise of judicial activism. It does not mean that the courts play an interventionist role in the guise of judicial activism. What does it mean then? It implies necessarily compliance with the spirit, the purport, and the objects of the Constitution. The spirit of the Constitution. The Constitution is not a dead writing. It's a jivi deyak. එය නිකන් පොතට පතට සීමා වෙච්ච ග්‍රන්ථයක් නොවේ කියන එක අපි වටහා ගත යුතුමයි. එය නම්‍යසුළු රටට සුදුසුසක් වෙන හිතට අර්ථකථනය කළ යුතු නීති පද්ධතියක්. So it is my view, respectfully, that the judiciary that fails to comply with the country's constitution in a constitutional democracy can be said to be participating in governance in a way that can hardly be described as good governance. So now that's a fairly difficult thing I'm saying. I'm saying that the judiciary that fails to comply with the country's constitution in a constitutional democracy can be said to be participating in, cannot be said to be participating in a way that can be described as good governance. Now, therefore, there cannot be a usurpation of each other's powers to the extent that there is an abdication. There cannot be a usurpation of each other's powers to the extent that there is an abdication. ඒ කියන්නේ මේ ආණ්ඩු ක්‍රමයයි ව්‍යවස්ථාවයි විධායකයයි අධිකරණය අතර තියෙන මේ වෙනස එකිනෙකාගේ බලය ඒ තියෙන ඒ පරමාධිකාරිය නැති වෙන විදිහට ක්‍රියා කිරීම නෙමෙයි ඕකේ අදහස. දැන් ඒ කියන්නේ එක්කෙනෙක් අනෙක් එක්කෙනාගේ ඒ තියෙන අනිත් කොටසේ තියෙන ඒ බලය ඒ නැති වෙන විදිහට ක්‍රියා නොකළ යුතු යන්නයි මගේ අදහස. එහෙම වුණොත්, if that happens, there will be an abdication of each other's authority. තමන්ගේ තියෙන පරමාධිකාරිය මේ අනිත් කෙනාට පූජා කරන එක විතරයි වෙන්නේ කියන එකයි මම මේ අදහස් කරන්නේ. So therefore, there cannot be a usurpation of each other's that will amount to an abdication. The adjudicatory process cannot be denuded, will go, if that happens, the adjudicatory process cannot denude the powers of another organ of state that would lead to abdication. There must be a respect for each other's powers. They might go side by side, but in one system of governance, although we talk of a separation. So therefore, the courts famously, the courts famously play their roles of policing in applications for judicial review. The courts time and again review executive action. The Constitution permits the judiciary to issue, quashing orders, prohibitions, mandamus, and the like, certiorari, and the like, when there is an exercise of power which has been excessive, or there is a failure to exercise power, when there is an omission, or when there has been a lack, as I said, a lack of power. Now, the Constitution, you will see, identifies and delineates the organs against which these orders can issue. කියන්නේ ව්‍යවස්ථාවෙම තියෙනවා මේ නියෝගයන් කා කෙරෙහිද මේක ක්‍රියා කළ හැක්කේ කියන එක. Now, if the enabling statute, මේ power එක දෙන statute එක, or the constitution prohibits scrutiny of the legislature in a particular domain, interventionism cannot take place in the name of judicial activism. If the constitution says no, you courts cannot actually intervene in a particular way, then that interventionism cannot take place in the guise of judicial activism. ඒ මුවාවෙන් කරන්න බෑ කියන එකයි ඔය කියන්නේ. Now, there are areas in our courts that the courts have exhibited time and again judicial activism. Now, take the fundamental rights jurisdiction, for example. The right to life, right, is not specifically specified in any other chapters of the fundamental rights jurisdiction. But you will see, you will appreciate as students of the law that the Supreme Court has brought in right to life through Article 13, Sub-Article 4 of the Constitution, which states that no person shall be punished with death or imprisonment except by an order of a competent court. Now, some constitutions in the world specifically provide for the right to life, but in our constitution we have approached it in a different way. We don't say it in that way. Maybe because we thought that the right to life was so sacrosanct that not even a constitution needs say it, that it is so implicit in the whole purpose of life. After all, life is so precious, isn't it? So there are therefore areas our courts have exhibited activism. Therefore, the Supreme Court, as you see, has policed the police, for example, by the excessors, by reading into that provision the right to life. An approach that reflects the maintenance. Now that approach, I say, is reflective of the maintenance of the rule of law, which in turn promotes good governance